The DPO Centre is the UK's leading independent data protection officer resource centre. The company offers expert advice and guidance to enable organisations to comply with relevant privacy and data protection legislation. Well, the DPO Centre team is located across the UK and is one of the largest independent permanently employed data protection officer teams available. And the range of services are extensive. They include the provision of outsourced data protection officers, auditing, compliance, reviews and consultancy services, EU and UK representation via their network of offices across Europe, and a confidential external subject access request response service. There really is a lot going on, and to tell me all about it is the DPO Centre's CEO Rob Masson and the head of DPOs, Lenitha Bishop. It's very good to see both of you. You're very busy people, clearly, so we appreciate the fact that you've taken the time to be here. But look, Rob, so much has been going on. Not just COVID, but also Brexit. Brexit has happened, but it's still unravelling. So how has that affected the way that data is transferred between countries? I would imagine it makes your job a bit more difficult, really.
Well, it certainly makes it more interesting, that's for sure. I mean, I think, obviously, in terms of Brexit, obviously that only affects transfers between the UK and the EU. Obviously, there's transfers to other countries, but that hasn't changed. That's essentially the same as it's always been and remains the same. But the problem, if there is one, is in transfers that are being made between the EU and the UK. And what's required in order to ensure that transfers are seamless is a decision called adequacy. And it's something that the European Union makes a decision as to whether the UK's data protection laws are equivalent, essentially equivalent to the EU's data protection laws. Now, of course, we've only literally just left the EU. And when we left, we adopted the EU GDPR as the UK GDPR. So essentially the same thing. And now they may diverge over time, but at the moment they're essentially the same thing. And what that means is that thankfully the European Commission came to a decision that says that the UK's data protection laws are, for the time being, essentially equivalent. And therefore, when they put that adequacy arrangement in place, it just means that personal data is allowed to flow from the EU back to the UK and vice versa, as it has been before Brexit.
So in that sense, there's no difference.
So that bit's a kind of tick in the box. That's the concerns that I think most privacy professionals had pre-Brexit that wasn't going to happen. Thankfully, that hasn't happened, and that decision's now been put in place. And so that's a sigh of relief, certainly, for most privacy professionals who are transferring data, because there are other mechanisms that can be used. I mean, so if we didn't get adequacy, then certainly there are other safeguards, they're called, that could be put into place. But that's a very complex area as well, because even that mechanism is under question at the moment. So there's some new arrangements have literally just been released by the European Union. And so it's an extremely complex area at the moment. One thing that has changed as a result of Brexit is the requirement for many organisations in the UK and actually in the EU to appoint a representative. So if you're a UK-based organisation and you're offering goods or services to EU residents, so not necessarily citizens but residents, but you do not have a presence in the EU, then because we're no longer part of the EU, you have to, the same as any other organisation in the US or Asia or wherever, you now have to appoint a representative. And that representative is there to be the point of contact for what are called data subjects, that's you and I, basically, the residents of the EU, and the regulators. And the idea is that if there's ever any kind of issue that's going on with the way that you're processing data, either the data subject, the individual, or the regulator contacts that representative. So as an organisation, we provide that particular service. We have the DPO Centre Europe in Dublin, and we have a network of offices throughout the EU. So we act as that representative for a number of UK organisations, and then vice versa as well.
Sure, but I mean, clearly it is very challenging because, as you said, there's always the risk at some stage of diversification.
Yep.
And I guess that until that happens, there's enough time between now and then to potentially predict which way it's likely to go and to have some sort of safeguards in place.
Yeah, I mean, it's very dynamic. So obviously Brexit was a kind of known issue. We knew it was coming, but we didn't quite know what the outcome was going to be. That's becoming a lot clearer, and the landscape is being defined. But globally, data protection laws are changing by the day, and there are new regulations coming in countries all over the world.
Sure.
So a data protection officer or your privacy professional that you take advice from has to be able to understand the implications of all these regulations that are coming in, and it's extremely difficult to do so. So it's something where it's extremely difficult for an individual to have all of that knowledge.
Yeah, let me just jump in here, because Lenitha, we've heard about the European challenge post-Brexit, but what is happening with data protection globally? Because it must be more complicated, because there is no one-size-fits-all standard here. It differs from one country to another, or within a state within a country.
Yeah.
The US being the classic example.
Exactly. So GDPR has been seen as the gold standard, if you like, and we've since then seen many other countries trying to replicate it to a degree, but not completely. And that's the challenge for privacy professionals, where you process data over multiple jurisdictions and you need to comply with all. I think, for example, South African's POPI law, both the GDPR and POPI have got financial fines, but you can also end up in jail, a 10-year jail term, as if you're the CEO of a company and there's a violation of POPI. And so it's very different things in different countries, and understanding where the risks lie is where it's paramount that your data protection officer or your privacy team understand the risks and you mitigate them. And then the flip side of that is you and I are becoming more aware of our rights, and the global awareness, I think, is probably best demonstrated with what happened in January with WhatsApp, where users received a notification saying we're sharing with our parent company, Facebook. Everyone has got their opinions as to what they do with personal data. And there was a mass migration across to Signal and Telegram, and Telegram, for one, had 25 million new users in something like 72 hours. And it just, users won't tolerate misuse of their personal data, and that global awareness puts organisations on the back foot almost, and they have to comply.
Sure.
And the ones that go beyond the bare minimum will earn trust, and just they'll be the ones that succeed.
And this is important, isn't it? Because the unifying theme here is that once upon a time a CEO was simply responsible for running the company. But now, of course, it's changed. There is a data architecture as well that he or indeed she has to be aware of, because if they fall short, there's the possibility of doing jail time.
In South Africa, yeah.
Well, certainly in South Africa,
yeah.
perhaps other countries as well.
Could be, but I think it's definitely boardroom level now. Obviously, the DPO needs to report to the most senior level as part of GDPR, the Data Protection Act. But it's no longer something you can just forget about. And the financial fines are one thing, but reputational,
and that's the point that I was going to make as well. It's the reputational damage. So as much as anything, if you want to protect your brand and to really promote it, that's why it's so important to have relationships with your company, because you can steer things in the right direction.
Exactly. And it's all coming around to what's called accountability. So if we look at something like the GDPR, it's kind of the regulation is principle based. So you are required to adhere to the principles, and one of those principles is accountability. And so you have to be accountable for the data that you're processing. Gone are the days where you could have a problem and put your hands up and go, "Oops, really sorry, didn't mean for that to happen.
Let's move on from it.
We're going to do this from now on." It's completely turned it round. So that, and this is what's put it up into the boardroom, is that you have to demonstrate that you were taking what's called appropriate technical and organisational measures to protect the data. And it's that side of things that has now made it such a C-suite kind of issue, because it's now the board's responsibility from that accountability perspective, and there you can't just leave it with the privacy team or the IT team and just say, oh well, kind of that's something for you. It is very much a board issue and a risk issue.
I mean, look, we know that the whole data landscape has been changing as well because of the technology, the surges, and the innovations that have been happening. But in what way did the global pandemic accelerate that change? What did it do?
I mean, straight away, it was all about working from home. I mean, we've gone from coming to work every single day into an office, into a nice, relatively secure environment from a data protection perspective, with equipment that's managed by your IT team, and and everything's as much as possible, fairly well protected. We've now gone home, and we're now, for the time being at least, we're all working from home, and that means that the processing of personal data is occurring at home, and it's occurring on your home laptop, or on your home Wi-Fi, and it's the same PC that your kids use, to do whatever they're doing with the machines. And so, what it means is that the organisations are they're losing control. So that you are a data controller. I mean, they use those words for a reason. You have to be in control of the data that you're responsible for. And when it's being processed at home, you are not as in control of that data. And so there are significant risks that are created from working from home, and you are unable or less able to apply the appropriate technical and organisational measures that you would normally be expected to apply in an office environment or a work environment, because you can't necessarily dictate exactly how someone processes data.
So the home office is effectively more unsafe than the formal office structure, or potentially more unsafe.
I mean, there is technology that you can use, and virtual networks and all these kind of things, where you are effectively logging on to the systems at work and performing the actions essentially just on the office equipment, but just from a home machine. And so there are certain things that can be done, but there will inevitably be data that is being processed kind of locally, and that creates problems for accountability. It creates problems, for applying technical and organisational measures, but it also creates problems for breaches and things like what are called data subject access requests, because the data is no longer visible, as it were, or controllable by the organisation. It's all sat at home. I mean, last year we produced a range of what we call working from home tips, which is soon after lockdown, which we published. They're available on the resources section of our website. But they're there to just give really quite basic advice to individuals who are working from home and processing data to help an organisation remain in control and to apply as best as possible the technical and organisational measures.
So it's actually quite universal, that advice, because it applies to most people. But something, whenever we're talking about data, we talk about technology and specifically AI, because if you think about it, again, it's made the harvesting of that data a lot more rapid, but at the same time you can't get away from regulation. Yep. So has the regulation kept pace? Does it give us the safety that we demand?
At the moment, not yet. So we've got a draft, or the EU has published a draft AI regulation that at the moment is leaps and bounds forward, but it's only a draft stage at the minute. I think what the key thing for us is, with great power comes great responsibility, and with that, facial recognition. And the problem with AI, well, not the problem, it could be used appropriately. However, in some instances, we've seen where people were wrongfully accused of a crime. You might have been declined a mortgage based on an algorithm, and it's the non-human element where you could potentially be negatively impacted, where people are saying, well, wait a minute, I'm not quite sure about this. There's a huge amount of benefits to it. I think it will propel any business that can implement something that is, with privacy in mind, fairness and transparency. It will propel them forward, hence the reason there's mass adoption. But the regulation is there to put, a framework in place and make sure it is used for good and not evil.
Sure.
But only time will tell.
But you're always going to have this issue with the framework of that regulation, that it's great today, but can it really keep pace with technology? Can you actually construct a piece of regulation which bears that in mind and it has that generic quality? So it doesn't really matter how rapid the technology is, you've still got that framework, something about it will hold.
And I think that's the idea with the AI framework, is it's future-proof to a degree, but time will tell. Technology is, it just accelerates so quickly, but it is that bare minimum framework to make sure, at least on the core of the principle privacy by design is there, and that whoever designs any piece of technology has got privacy in mind, and it's not the commercial element is there, but it goes hand in hand with the privacy.
Yeah, which is often where the human touch comes into it as well, because that's where, whenever we have these conversations about AI, it tends to be, well, the machines take over everything, but a lot of people say, no, they can't, because you need to have the human hand to actually give you that empathy, so that, as you pointed out, Lenitha, that you don't have situations where people are actually denied a mortgage for whatever reason. But Rob, I mean, look, international data transfers, they actually top the list of concerns in the latest data protection index, perhaps unsurprisingly, but why? Is it because of the surge of technology and just how rapid the takeover appears to be?
I mean, it is. So just to give a bit of background on that, the UK Data Protection Index is it's a panel survey that is conducted on a quarterly basis. So it's a survey that the DPO Centre sponsors, along with another organisation called Data Protection World Forum, but it's run by an independent research company. And we have a panel of just over 400 data protection officers that are UK based, and they're from a range of organisation sizes and industry sectors. And what the index survey is there to do is, so when a DPO joins, they give some basic information on themselves, but then every quarter we essentially ask them the same questions. And what it enables us to do is to identify how opinions are changing over time. But underlying all of this, we ask one of the questions, what is the key current issue that you're facing in order to comply with data protection laws? And what we've seen is that in successive quarters, international data transfers is the key issue, and it's accelerated since last year, because what happened last year, we had a couple of really quite fundamental legal decisions that were made regarding international data transfers, and it was basically what's called TREMS 2, which is a very long-running legal disagreement between Facebook and the Irish Data Protection Commission and a chap called Max Schrems, who's an Austrian privacy advocate. And what happened was the outcome, a long and a short of it, very short story, is that this mechanism called Privacy Shield, which is a mechanism that allows the transfer of data between the EU and the US, was invalidated. So overnight, all of a sudden, there was this massive problem of being able to transfer data to the US. And of course, the US essentially houses all of our data, because all the big platform providers and the Amazon Web Services of this world, and Google and all these kind of, they've all made a very quick change. But I mean, basically all the data was arriving in or ending up in the US. And so all of a sudden the mechanism disappeared. And so we're in this situation where what we needed to do was to switch to an alternative mechanism. And again, it's a slightly technical thing, but there's this thing called standard contractual clauses. And so without Privacy Shield, you fall back to standard contractual clauses, everything's fine. But of course, the same piece of the outcome of that particular case called the SECs into question as well. So all of a sudden, the entire privacy industry was kind of looking around, going,
"It's called a domino effect."
Yeah. It's like, what do we do? And to a degree that the situation remains the case even now. Things are improving. We've got a new version of SECs, and there's certain decisions being made about potentially even a new Privacy Shield coming along. And so the solutions are starting to come out, but at the moment it's very difficult.
But it's not necessarily a bad thing if it's generated this new thinking and really sort of brought the privacy people into contact with how people think. That as far as they're concerned, look, information, data, it may be the new oil, but it doesn't mean that you get a free pass on this. It's ours. It's the only thing over which we have some protections. So come on, let us get involved in this.
Exactly. Fundamentally, the way that the EU looks at it is if data is going to go, personal data is going to travel outside of the EU, it must be protected must have similar protections that it would have had if it remained within the EU. And there are certain countries where that cannot be guaranteed. And the US, and I'm not singling out just the US, because there's lots of countries. The UK is actually quite similar, where their surveillance laws essentially enable blanket access to data, and that means that it doesn't have the same protections or similar protections as it would have within the EU. And so this has caused and is causing more and more problems, and it's not surprising therefore that the DPOs on our panel are identifying this as one of, if not their key issue over time, and it seems to be kind of growing and growing. And it comes back to that issue we discussed a minute ago about the fact that every week another country is releasing a new data protection law. There's obviously 50 US states that are trying to come up with their own until federal law arrives, and so it's extremely difficult for an individual to have the sufficient knowledge of everything that's going on in order to advise certainly a large company that has lots of international transfers. And you effectively do need the size of a team like we have at the DPO Centre to be able to advise an organisation.
Sure. But look, what this all points to, or two things. First of all, lots of pressure, but you guys seem to be thriving on it, so congratulations. But essentially, it points to disruption. We tend to talk about disruption in terms of big tech companies coming in and changing the way that we live, the way that we do things. This is something much more fundamental. So, Lenitha, how does the DPO Centre actually help businesses through this disruption? Because there is a sense of do or die about this. If you get it right, then you can move on to the next level. If you get it wrong, you either stay stuck at the bottom or you disappear off the scene altogether.
Exactly. So what we do is we help organisations understand the data landscape and help them understand what they don't even know, because that's arguably the bigger risk. And we combine that with our own expertise in the sector, and then we provide practical solution-driven advice, and it's the commercial slant on it, because the regulation is very black and white, but you need to take a commercial approach, that risk-based approach, to be able to thrive as a business. And that, moving alongside with that, compliance is a journey, it's not a destination. We have many people say, well, I want to be compliant, can you give me a certificate? It's like, it doesn't work like that. It's something embedded in your organisation. You need to do it day in and day out. It needs to be part of everything everyone does. And that's the purpose, is to really, coming back to Rob's point about accountability, it's not only the CEO's responsibility, it's everyone in the organisation's responsibility.
But at what point do you guys need to come into that business? Because clearly what you do is really important, but is it an involvement that has to start at the very beginning of that business when it's an infant, or is it sort of the stage when it's somewhere between a teenager and an adult equivalent?
There's benefits to, to every approach to it really, but we come in with a small startup and we help with the framework in place. We've got clients where they've been doing it for years and they want someone to come and have an expert look and actually just audit and make sure they are doing what they're doing correctly.
Is it a monthly audit? Or?
Yeah, so we do annual audits, and then our DPO service is an ongoing, monthly arrangement where we both reactively and proactively drive compliance forward. So if there's a breach, we'll deal with that, but also making sure that policies are in place, procedures are in place, staff training. And then we also do more strategic pieces where you take a step back and you say, well, this is where we're at, this is where we want to be, how do we get there? And so we go in all phases and all elements of sizes of businesses.
I think there's a lot of organisations that did a lot of work on the build up to 2018, May 25th, 2018, when the GDPR first came in. So there was a lot of hype around that time, and organisations generally did a lot of work to get themselves to a point where they can kind of tick the box that says, yep, we're we're GDPR compliant, but they haven't necessarily done a great deal since, and so.
They got complacent, basically.
Well, I mean, I think that they saw it as a destination rather than the journey. So it was, May 25th is coming. There's our deadline. Work out what needs doing, get to that point, tick the box, which generally a lot of organisations did. But what we find is that in the kind of mid-size organisations, they did that exercise, but they haven't necessarily continued the journey from there, and things have fallen behind, and things have evolved, and what. Certain understandings, shall we say, in 2018 have evolved 3 years later, and new approaches need to be taken. And so we find a lot of organisations that we're going into at the moment, they had that grounding back in 2018, but they haven't necessarily moved it forward since.
And there's also a case of someone's been told to be the GDPR person. Someone in HR, IT, the office manager said, well, look after data protection. They've sort of done a bit and now realised with for all the reasons we've discussed, they're completely out of depth. They just don't understand.
Well, HR is HR, so why are you giving them data protection to handle?
And they've got a day job at the end of the day, and that's where most of our clients see the benefit of having that sort of external sounding board, and also being external brings the benefit of, you're independent, whereas if you're internal, there's always a bit of is it really your job?
And the risk of corner cutting as well.
Exactly.
Yeah.
I mean, look, can I put this question really to both of you? So starting first with you, Rob, because look, lots of people will be watching this. So is there one key piece of advice that you give to any CEOs who are viewing this who perhaps may have been pretty easygoing about the whole data protection issue? What would you say to them?
It hasn't really changed right from the beginning. It's understand your data. As soon as you have a grip on what data you've got, and where it is, and who has access to it, and how long you keep it for, and all these kind of things, you will be able to build a framework around it. But so many organisations don't fully understand where their personal data is stored, and the protections that are applied to it. And so one of the things that we generally do whenever we start an exercise with a client is to do that data mapping exercise, is to look at the organisation as a whole and go from department to department saying, what have you got, where is it, how do you process things, and build up that map, which then turns into this thing called records of processing activities. And that's the base document that we will generally use in order to build a framework going forward.
Okay, and Lenitha.
Summed up, it's not too late. It really isn't.
That's reassuring.
Arguably it should have been done, but reach out. There are people that are can help take the burden away, and just make sure going forward you've got the right framework in place.
Okay, look, some sound advice there. Great optimistic note on which to end our conversation. Lenitha and Rob, thank you so much for being here and for putting our minds at ease about data protection. It's scary, isn't it?
It can be. It can, if you don't, if you're coming at it without a level of understanding, then it can just be a huge hill in front of you. And sometimes it's easier just to turn away and do something different. But that's exactly where we help. We can get you to the top of that hill, and we can solve the issues that you're facing.
Fantastic. It always helps if you have a good navigator on hand. Great
Exactly.
speaking to you. Thank you.
My pleasure.
Thank you.